This is not your children's fault. This is only one person's fault, and that is yours. No one forced you to get behind the wheel of the car when you got arrested for DUI in violation of that court order. No one forced you to have these beer cans and alcohol present in your house. I find by the credible proof in this court, that is not one of your finest moments. And I would have thought maybe that would imprint itself enough upon you that you would not want to have alcohol in your house under any circumstances when they're there. Back on the record in Phelps versus Phelps, we've heard testimonies from the children, so we'll now hear from any other witnesses. Ms. Roberts.
Yes, Your Honor, and I just wanted to clarify something that counsel had brought up. I initially filed the petition for contempt, and I filed that on December 15th. Out of an abundance of caution, I refiled it in March simply because we had the hearing on November 5th. I typed up the order. You signed it on December 10th, but it did not get stamp filed until December 15th, the same day that I filed the original contempt. So out of an abundance of caution with a notice issue, because they would have not known on the 15th, the defendant would not have known that the order went into quote unquote effect, because I filed the contempt on the same day that the order was technically made of record. So I refiled it so that there wasn't a question of notice that the order was not in effect. So that's why it was refiled on March 3rd, I think. So that was
All right.
that was an issue that was done, Your Honor. And I would call my client, Ms. Miles.
All right, ma'am, if you'll come up, please.
Would you state your name for the record, please, ma'am?
Chastity Miles.
And Ms. Miles, where do you reside?
1212 Mount John Road.
And you and Mr. Brian Keith Phelps have 2 children born of your marriage, is that correct?
Yes.
And what are their names and ages?
Bentley Phelps, and he is 14. He just turned 14. And Shaylin Phelps, and she just turned 11.
Okay. And y'all were divorced by decree of this court, is that correct?
Yes.
And do you recall about when that was?
Called in September, and I believe it was finalized in January.
Okay. And pursuant to your final decree, a parenting plan was entered, is that correct?
Yes.
And I have a stamp filed copy that showed that it was entered on January 4th of 2024. Does that comply with your recollection?
Yes.
You got a copy of the parenting plan. Your Honor, may I approach?
You may.
Yes. 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 The father shall not consume alcohol to excess during his parenting time. Mr. Phelps had a drinking problem during our marriage.
Okay. And to your knowledge, did he voluntarily enter into this agreement?
Yes.
Has he ever raised an issue that he was forced, threatened, or otherwise
No.
did not agree with the terms of this agreement?
No.
Have y'all followed the terms of the residential schedule?
Yes.
Have y'all made some deviations when you needed it?
Yes.
Okay. And do you know, was there any reason why that you would be aware that Mr. Phelps was not capable of understanding the plain language of this order?
No.
Did you discover at some point in time that during the residential time that he was exercising with y'all's children, an event transpired that resulted in Mr. Brian Keith Phelps being arrested? Did you discover sometime that he had been arrested? And did you have a conversation with him about that? How did you find out?
A friend called me and told me that they saw his mugshot.
Okay. And you did some investigating
Yes.
and found out that he had been charged with driving under the influence and reckless endangerment because your oldest child was in the car. Is that correct?
Yes.
Did you reach out to him, or did he reach out to you and say, hey, this?
He did not reach out to me. I sent him a message that was in a group text with my mom and his mom asking if we could chat about what transpired, and I sent a picture of his mugshot.
And what happened with that?
No response on the group chat.
Okay. And then we had filed a petition with this court seeking a modification alleging those facts had occurred. Is that correct?
Yes,
And we came to court in November of 2025, and you were present at the time. Is that right?
yes,
And were you present during Mr. Brian Kiesfeld's testimony?
yes,
Did you hear him testify?
yes,
And again, we filed a petition for contempt, and we set forth in that petition for contempt certain allegations. And did you read that
yes,
petition? And were those allegations true?
yes,
Do you recall whether or not that Mr. Brian Keith Phelps admitted under oath that he consumed 8 to 9 alcoholic beverages while he was at a local swimming hole with your son, Bentley?
yes,
Did he testify that he blew a .19 when he was arrested and subjected to a breathalyzer test, or excuse me, had a blood test?
yes,
At that point in time, was he questioned, and did he admit that he knew there was a prohibition about him drinking to excess with the children?
yes.
Are you familiar with whether or not he was found guilty pursuant to a plea of guilty?
Yes, I was present at his court hearing.
So you did where court was that in?
Bronx.
Okay. And you were present and heard him admit that he was driving at his plea hearing, as well as in this courtroom, sitting from the same place you were sitting right now. Is that correct? We came to court after that. We came to court on that November 5th, and were you aware of what terms and conditions the court set down?
Yes.
And you have the order from the November hearing? Your Honor, may I approach?
You may.
It is ordered, adjudged, and decreed that the respondent, Brian Keith Phelps, shall remain as set forth in the permanent parenting plan, but he is specifically restrained, enjoined, and prohibited from consuming, possessing, or in any way subjecting the parties, minor children, to any type of alcohol during his residential time, including but not limited to his own personal use, or allowing any other individual, including his current paramour, from consuming, possessing, or in any way subjecting the minor children to any type of alcohol. It is ordered, adjudged, and decreed that there will be no alcohol beverages at the home where the respondent is exercising his parenting time.
With y'all's children?
Yes, he rents a home on 1070 James Circle.
And at some point in time, your children at the time were 11 and 13 when this happened. They've just recently turned
Yes, so they
well,
have been 10 and 13.
10 and 13, excuse me. Did you communicate with your children that certain restrictions had been put down by the court?
Yes, after the day that we came home from the court, I made them aware of what the judge had ordered,
Okay. And why did you do that?
so they knew the truth.
Okay. In what manner did you tell them?
Told them that me and their father had went to court, and the judge ordered that there would be no alcohol consumed or in the house or around them during his parenting time.
Were you under the understanding that your son was in the car when he drove drunk?
I didn't find out until 2 days after Mr. Phelps
But when
was
you found
arrested.
out he was arrested, you did know that
Yes,
Bentley was in the car. Were you aware that your daughter came to the scene?
after the fact, yes.
Okay. Do you know whether or not they left before he was arrested and done stuff, or did they watch it?
I was notified that the officer did Mr. Phelps a favor by letting the children leave before she arrested him.
So have you seen the effect that this arrest has had on your children, particularly your son Bentley?
Yes.
Can you describe what that is, what you've seen?
Roberts, I hate to interrupt, but this is just a petition for contempt, right?
Right, and again, this is, the reason I'm getting into this, Your Honor, is simply because you witnessed the child's testimony.
I did.
And so just in the measure of truth and veracity, if there's a question as to what happened with the children, the reason that I'm getting into that is simply because you have to judge the truthfulness and veracity of the witnesses. And that's why I was having this, not from a custody standpoint.
Right.
So,
For that reason, I don't allow it.
I feel like Bentley has a hard time when it comes to his father. He doesn't want to get his father in trouble. And so he tries to avoid conflict and shuts down.
okay. And the same question with Shayla. Again, you weren't present when the children's testifying.
Mhm.
But again, and you prefaced it, you don't feel like Bentley wants to get his father in trouble.
Mhm.
So it begs the question, do you think Shayla wants to get her father in trouble?
I don't think that she wants to get him in trouble, but she knows that he's not supposed to be doing things, and she's a little bit more vocal on you shouldn't be doing that versus Bentley just bats an eye and doesn't want to be involved because therefore he can't say anything.
Okay. But have they been truthful to you about things that have gone on in the house over there?
Yes.
And in that vein, did you ever instruct your daughter to do anything while she was at her father's house?
No.
But has she done some things while she's at her father's house about giving you information?
Yes. She's asked several questions about being at a restaurant and them talking about ordering drinks. She's texted me and asked me if they could do that. If they're at someone's house and someone is drinking, she just in conversation exploits that information. It's not like I'm asking 21 questions to get the information out of her.
Is she a rule follower?
Yes.
And has she, over the course of several months since we were in court back in November, routinely sent you photographs of things that have transpired or she has witnessed in the home?
Yes.
And the home being Mr. Phelps' home?
Yes.
May I have the exhibit? Do you believe each and every one of those photographs and the dates done depict a violation of this court's order,
Yes.
as well as his conviction and his admission of driving
Yes.
intoxicated violates your original parenting plan? Is that correct?
Yes.
You believe that he has the capability of understanding and comprehending? In fact, is there a audio recording, a video recording that you had where he makes statements?
Yes.
And what is that?
I asked him why he was driving a vehicle with not an interlock system, and he said that he had a piece of paper stating that he could do so, and if I had a problem with it, to take him to court.
Okay. And you obliged, is that correct?
Yes.
Do you know whether or not, do you punish your children when they disobey you? And what type of punishment do you impose on your children?
Usually I take things away, PlayStation or a phone, or I don't let them do something.
Okay. Are you aware personally whether or not Mr. Phelps requires the children when they're in his possession and during his residual time that they have to follow certain rules?
Yes.
And if they don't follow the rules at his house, do you believe or understand from your personal knowledge and conversations with him that they're subject to punishment?
I don't have conversations with him about punishment. But the kids have told me that they've been punished for certain things over there.
Okay. So if your house that you have to apply by rules and at his house, your children have to apply by rules and there's punishments attached to that, do you believe when you disobey or he disobeys rules that y'all should, punishment should attach?
Yes,
Do you think that's a significant example that your children need to learn?
yes,
Are you concerned for your children's safety if Mr. Phelps does not understand the gravity of the fact that he has to comply with the rules that are set down for him?
yes.
That's all.
Or you may ask.
Ms. Phelps, or excuse me, I apologize. Ms. Miles, do you attempt to co-parent with Mr. Phelps?
Yes.
Okay. Why was there no attempt to co-parent with Mr. Phelps as it came about with this order and what was to be done at his house? You stated that you took it upon yourself to tell the children what was to be occurring at his home. I would like to know, I think the court would like to know why you didn't see that as an opportunity to co-parent and ensure that the father was aware of that situation.
I'm sorry, I'm blowing my nose. Repeat your question. Yeah, Jeffrey. Sustained, the court will speak for itself.
Why is it, ma'am, that you did not see that it would be a good idea to co-parent, tell the children along with the father so that they were on the same page?
Didn't see that it was necessary to have a conversation with him about that. We don't talk about that with our children together. We don't do anything together. As far as communication, we do communicate. But when it comes to sporting events or anything like that, we separate and there's nothing talked about.
But you would testify that you made your children well aware of what was occurring in court.
To an age appropriate degree, yes.
And you would then also then say that you were receptive of your daughter sending you the photographs, correct?
Yes.
Okay. Is it your testimony that you did not ask her to make these photographs?
No, I did not.
Is it your testimony that you've never inquired upon her to take further photographs?
She has asked me what she should do, if she should take a picture, and I've replied yes. But other than that, I have not given any other authorization or advice to her on what she should do.
And again, in an attempt to co-parent, that did not happen. You did not make a communication with the father, correct?
As far as Shaylin taking pictures and sending them to me,
Yes, ma'am.
no, I did not.
With the alcohol that you say that you see in the photographs that came from the Shaylin, according to your testimony, did you attempt to talk to the father about that?
No, I did not.
You're aware that your daughter has no issue with finding her father in trouble, correct?
What's the question?
You're aware that your daughter has no issue finding her father in trouble. She's pleased to show you these photographs.
It's not that she's pleased. She wants to make sure that he's doing what he's supposed to be doing.
Actually, that's to the formula. Sustain the objection.
It's, again, you've not declined the photographs and you've not spoken to the father about the photographs, correct? You are aware that you are to attempt to co-parent with the father, correct?
How am I supposed to co-parent with him regarding that when he is not doing what he's supposed to be doing?
Well, ma'am, I will get to ask the questions from here. You are aware that as part of your parenting plan, we talked about your parenting plan today, so we're going to bring that back up. The first thing in there is an attempt to co-parent. But you're stating today to the court that you've not made any communication with the father concerning this, correct?
Not about the photographs, no.
You also have said that your daughter is a rule follower. But you then testified to her having, at her father's house, been in trouble, I'm assuming for not following his rules.
I don't know what goes on over there other than what they tell me.
Okay, what has she told you she's in trouble for then?
Lots of things.
Could you please enlighten us?
Being disrespectful to Jennifer.
Okay.
Having an attitude, having a smart mouth.
You feel in no way that affects her desire to then retaliate against her father?
The photographs have not necessarily been sent when she's in trouble.
Now, you've never been in Mr. Phelps' current home, correct? Okay, and these photographs that you have in your possession, showing what alleges to be alcoholic beverages or cans, you've never physically seen those either, have you?
Just from the photographs.
Just from the photographs. So you've never laid hands on any of the beverages? Okay, you're not aware of whether or not they were empty, potentially in a recycle bin?
No,
Now, are you aware of the fact that this court does not have an order? This court does not have an order for Mr. Phelps to be utilizing an interlock system.
he's court ordered by Robertson County.
Yes, ma'am. But my question is you're aware that that is not this court, correct?
Yes.
Now, in drafting a petition, you've got two petitions for contempt. And I went back through both of them. And we have constitutional rights. We have due process rights. We're supposed to know specifically what the allegations made against us and what are made against my client are. Are you aware of how many times the word allege occurs within your petition? If I may approach you.
You know,
And a start with the paragraph specifically, the allegation.
Okay.
Anywhere in that petition, the third of my client, and an allegation.
What was the question?
There anywhere in that document, you, give it to the. Anywhere in the document.
I mean, I don't know. You just have stars and
Yeah.
I don't understand what you're asking. Yes, I know I signed it. Yes, I've already looked at it. I've signed it. I don't know a specific number, but we wouldn't have put it in there if it wasn't against Mr. Phelps.
I'll read for you a paragraph number 9 from your petition, which was issued with this court on March 3rd, 2026. Paragraph 9 states, petitioner would allege that on January 31st, 2026, the respondent again had an alcoholic beverage in the home during the time the party's minor child had scheduled residential time as evidenced by the photograph attached hereto as Exhibit B. Do you understand that to be an allegation against Mr. Phelps for which he has to answer?
Yes,
Also, paragraph 11 of that document states, petitioner would allege that respondent's actions in having an alcoholic beverage at the residence where the respondent exercised his residential time with the children is in direct violation of this court's order and constitutes willful and deliberate contempt, criminal contempt of the orders of this court. That is a specific allegation. Now, to which order it is specifically stating is being violated, that is not written at this time either, is it?
it just says alleged.
And it also says just of the orders of this court, correct? It's not dealt with specificity.
It states clearly pursuant to that order of this honorable court, respondent filed and was specifically restrained into doing activity or something. The best thing for underline, highlight, or underline and bold, in any way subjecting minor children to any type of alcohol, drink, possession, including but not limited to his personal use for around the other individual, including his current parent or possession of any one subjecting minor children to any type of alcohol.
As far as your objection to a misstatement of the order, the sustain the objection.
Now, ma'am, I'm assuming you've been around Mr. Phelps. You've not seen him under the influence of alcohol, correct?
The only time I really see him is at drop off and at sports or a school event.
So you've not seen him under the influence of alcohol, correct? Your children have not told you that he's under the influence of alcohol, correct?
That's not true.
So they have told you that he is under the influence of alcohol. Please tell me about when that occurred.
They have assumed that he has been drinking based off of his behavior.
Please, with specific detail, elaborate upon when they made such assumption.
I don't have dates or times.
Would it shock you if they were to have testified that they have not seen their father under alcohol, under the influence of alcohol?
Sustain the objection. I think that the children's testimony was they had not seen him under the influence of drinking alcohol since the driving under the influence, or was it the,
Since
they
the,
indicated that it was since those photographs were taken, they had not seen him under the influence.
Your Honor, it was my understanding that the daughter stated that since the order where he wasn't to drink, she has not seen him under that. And that the prior order was that he was allowed to drink, not to excess.
I'll note that.
Your Honor, I have nothing further.
Please, Rick.
Do you, again, counsel asked you about co-parenting with Mr. Phelps. What happens if you try to have a conversation with him?
There has been some instances where I gave him documentation of dental work, or I've texted him and there's been no response.
If I could, shortly after we were in court on December 5th, did you have an opportunity to meet him somewhere to pick up the children?
We always meet at a specific location on Fridays at 6 p.m.
And again, you have a video that I was going to, somehow my computer, the internet, I can't download it to do it on the internet, but I'm going to just play the audio. Did you record a conversation that transpired between you and him when you were trying to discuss him driving with the children?
Yes.
If I could.
I can too. You're not supposed to be driving this vehicle. No, you cannot. Is there a breathalyzer in it? Why? You are not supposed to be driving a vehicle that does not have a breathalyzer in it. I will, because you are violating. Yes, you are. Okay. Love you.
Did you attempt shortly after we were in court to not have him drive with your children?
Yes.
Did he become angry and agitated? And that illustrated the conversation. Is that correct? Again, begs the question, do you have to treat him like a child and spoon him the rules on what he's supposed to do? Your Honor, again, it comes up to the situation. Your Honor has to determine whether or not the defendant's actions were willful. Counsel has raised the issue by saying that this woman has an obligation to, quote unquote, using the words co-parent, to talk to him and explain to him what he can and can't do with the children. So that's the basis of my question, is it was raised on cross-examination saying that she has some obligation in the terms of co-parenting to tell him what the order says.
None of which has any relevance to the question of whether or not this defendant, who is on trial for criminal contempt, did or did not willfully violate a court order.
I'll move on, Your Honor.
It's not relevant. And if your objection had been as to the relevance, I would have sustained it, but otherwise it's overruled.
I'll move on, Your Honor. That's all.
Thank you, ma'am. You may step down. Ms. Roberts, you have any other witnesses? Petitioner or plaintiff has rested their proof. Do you have any witnesses you wish to call?
Your Honor, there's not again, different basis we not to prove this not how my client has disobeyed court order. It's my understanding in reading this here petition, the only way that I can deduce an allegation is from the word petitioner alleged. He's alleging that he violated the most recent court order, and I would say that at this point in time that he has been beyond.
Overruled your motion for judgment by acquittal. Court finds that there has been sufficient evidence introduced that would sustain a motion for judgment of acquittal. The question then arises as to whether or not you wish to throw in the proof.
Yes, Your Honor.
Call your first witness.
All of that.
Stand up, raise your right hand and face the clerk. I do.
Mr. Phelps, you understand why you're here today?
Yes, sir.
All right. Do you recall being here previously?
Yes, sir.
You recall confessing to this court what it was that you felt at that point in time you were guilty of?
Yes, sir.
Do you recall the many conversations that we had after that court hearing?
Yes, sir.
Have you violated any of the court's orders since the moment in time we left this courthouse? I believe it was in November, Council, in November of 2025.
No, sir, I have not.
Do you consume alcohol in the presence of your children?
No, sir.
Do you keep alcohol in the presence of your children?
No, sir.
Are you full well aware of what the court's order is pertaining to alcohol in your children?
Yes, sir.
Are you currently abiding by all of the, I'm sorry, Your Honor, I'm losing my word, all the terms of your agreement with the criminal court out of Robertson County as it pertains to your DUI?
Yes, sir.
All right. Do you currently have the proper insurances, interlocks, and everything that is necessary in order to commute?
Yes, sir.
And your statement today is that you don't have alcohol around these children. You do not violate this court's order.
Everything's good. Yes, sir.
Do you feel that Maybe sometimes things are done against you.
I've learned to believe that. Yes, sir.
Are you fearful that some things may be staged against you?
Saying don't leave the witness.
Is there anything that your daughter's doing that you're fearful may not be truthful?
Yes, sir. I mean, this is my freedom where I feel like my freedom's being played up, tossed around like a tennis ball, and I take that very serious. Very serious.
You appeared nervous when we were in court last time. You appear to be not as nervous this time.
Yes, sir.
Why is that?
I've no clue. I know I've done everything right. The
Maybe
right
is
way,
that-
done what the court has told me to do.
Is that maybe why you're not as nervous this time? Because you feel in your heart?
Saying don't leave the witness.
Is that why you feel that way?
Yes, sir.
Because of your previous statement? It's because it's in your heart?
Court ordered me not to have it around kids, not in the house, being under the consumption of it when I had them kids. And that is what we've done. We have went out to Texas Roadhouse. We do go out and eat.
You're stating that because there's alcohol in a restaurant?
Yes. Other than that, that's all there around it. We don't partake in that. Not only do I not, Jennifer does not neither.
And who's Jennifer?
My girlfriend.
Live-in girlfriend?
Yes, sir.
When you say you do not partake in that, clarify that statement for me, please.
We do not have no alcohol around. We do not consume alcohol. It's,
Now, do you consume alcohol when you do not have your children?
we do,
What's your parenting plan currently? Are you on a week off, week on?
Friday to Friday. Yes, sir.
So there's an entire week that you have where you would state you do consume
We get
alcohol.
off, yes, sir.
But again, it's your testimony that never in front of your children does that occur.
Never do. I haven't since the last time we left.
Do you recycle?
Yes, sir, we do.
Okay, and in your recycling bin, what might one find?
The beer cans,
Are there other, do y'all recycle other things?
Diet Mountain Dew, Dr. Pepper's cans, cat food cans.
But you're a recycling household?
Yes,
It would it be safe to assume that one might find a beer can in your recycling bin at this
Yes.
moment?
yes,
But that's not endangering your children or putting them in the presence of alcohol?
no, sir.
Those are my questions, John.
Mr. Roberts, you're across examine.
You think that she's just a vindictive, conniving something and just trying to get at you?
No, ma'am, I don't, but I know that since we left court last time, I have not done anything to jeopardize me seeing my kids going through that. I don't know where she has come up with these pictures. The one of me driving, I do. The ones with the, I did. I did. I was uneducated on that.
You drove there. You put the children in the car, or they got in the car. She told you you're not supposed to drive,
Yes, ma'am.
and you yelled back, "I got papers."
I didn't know.
No, you said, do you want me to play that back?
No, ma'am, no, ma'am. No.
You said you have papers. And you did not, did you?
But I didn't think that it said on the papers that I couldn't drive nothing but that. And I did get that clarified up right after that. And that was, I think, around January, somewhere around my birthday.
How did you get it clarified? Go to your probation officer?
Yeah, I called her, yes, ma'am, and it has not happened since.
You understand you signed documents in court in Robertson County saying what the terms and conditions. Your Honor, it goes to the first allegation of contempt with
Well-
alleged.
Number one, it is the first allegation of contempt, but are you talking about the fact that he was convicted of DUI?
Yes, sir. And the reason I'm asking this question is he is saying he did not know that he was not to be able to drive. So when it goes to the terms and conditions of complying with a court order, then I'm bringing it up.
That's the credibility.
Yes, Your Honor.
Overall.
So you You have already testified in this court and you admitted in Robertson County that you operated a motor vehicle after consuming 8 to 9 alcoholic beverages, beers, I believe it was. And you had a blood test that registered 0.19.
Yes, ma'am.
Did you have an attorney over there?
Yes, ma'am.
So you were legally, who represented you over there?
Jeff Walker.
Okay, so Mr. Walker, represented you, worked out a plea agreement, correct? And you've already admitted that you knew the terms and conditions of your parenting plan says you could not drink in excess with your children, correct? And you had your son with you, correct?
Yes.
And you drove. So you were in the lake, in the swimming hole, wherever it was, drinking alcohol with your son.
Yes, ma'am.
You were the adult there responsible for him,
Yes, ma'am.
and you elected to put him in the car and drive with him.
Right.
Do you understand, or were you told that your son testified that you were straying off the road, you were messing with the radio, and he had to tell you to pay attention to drive?
Yes, ma'am.
And that was a true statement that he made, didn't you?
Yes, ma'am.
And the police came back and pulled you over,
Yes, ma'am.
allowed you with courtesy to call somebody to come pick up your son, and that was your girlfriend.
He called.
Well,
I didn't tell him.
so your daughter came to the scene where you were pulled over and your son was there in the car. And you keep saying you did nothing wrong. Do you understand you could have killed your son?
I know that. Yes, ma'am. That
Then
was,
why did you do it?
I have learned from that.
You've learned from that.
Yes,
Okay.
yes, ma'am.
Put a pin in that. We're going to come back to in just a minute. So you went to court, accepted responsibility for your actions, and were placed on probation.
Yes, ma'am.
The terms and conditions of your probation were explained to you, correct? You met with a probation officer.
Yes, ma'am.
There was a sheet of paper that you were supposed to click off. And she explained it to you. It's a female, correct?
Yes, ma'am.
And you went over it, said you explained it and signed it.
Yes, ma'am.
And one of those was that you couldn't drive. You had to operate a car with an interlock device on it, correct?
I can't remember that part, but yes, ma'am.
Well, you said you didn't remember it until she told you, and you said you had papers, then you called and checked.
I didn't have papers.
But you told her you had papers,
I was going by the ones that I got from the judge.
the ones that you got from the judge.
And yes, ma'am, that we left for my DUI.
Okay. And you understand, if I could approach.
I don't understand the suspended because
You don't
they
understand.
went
what-
straight to restricted. I went straight and got them with me.
Sir, the reason I handed you that is because I asked about that you told your ex-wife that you had papers. And then you said you got it from the judge. That's the judge's judgment. So where on there says that you can,
Let me clarify what I was saying as far as that. I didn't know that I couldn't drive no other vehicle. I thought I just had to get the interlock put on my truck. That's what I was.
DUI, you just get the interlock put on and you can drive whatever you want to.
With all due respect, ma'am, that was my first and last one. I was new at it.
But that's what your understanding
I know
is.
now. Yes, ma'am.
Okay. And nobody explained in court to you that you were violating a court order by doing that.
Not at that time, no, ma'am.
But you understand you violated this court's order by getting drunk with your kid. If you hadn't even driven, you had not gotten in the car, you called your girlfriend and picked it up. You got drunk at the swimming hole with your then 13-year-old son,
Yes,
didn't
ma'am.
you?
Yes, ma'am, I understand.
And you knew, did you not, that that was a prohibition that was issued by this court
Yes, ma'am.
in January of 2024?
Yes, yes, ma'am.
And you ultimately disregarded and said, "Psh, whatever, I'm going to do what I want to do." Because you sat in that witness chair on November 5th and said, "I'm an adult, I can drink." Didn't you?
Ma'am.
And you have elected to continue to do that.
No, when I do not have kids.
I didn't put a qualifier. You continue to drink.
Yes,
Because you talked earlier when I said put a pin in it, I've learned my lesson. You also understand on November 5th, you were sitting in court, sitting in that chair right there when this court gave a ruling, weren't you?
Yes, ma'am.
And you heard directly from this judge saying, you are not going to even have alcoholic beverage in the house.
Yes, ma'am.
And you have had alcoholic beverage in your home after that date. Isn't that correct?
I don't recall it being in that date. Yes, ma'am, but not when I have kids.
So your daughters broke in your house and taken pictures?
I don't know where they come from.
Yeah. Oh, there they are. You forget your words and I lose the picture. All righty. Your Honor, may I approach? And I realize we had you to.
But she's been introduced to this children's house. And there's a twisted tea. See that?
That's tea.
Twisted tea, you know.
That's twisted tea. Yes, ma'am.
And she been in the closet, and there's a case of twisted tea.
I see a case of twisted tea.
And then she took a picture of the refrigerator, and there's some, not much on beer. What's that? What kind of beer is that right
It
there?
looks to be Michelob.
Big fun.
Yes, ma'am.
And that was in your house with your child, and your dogs.
I don't know that. It wasn't, it shouldn't have been, no ma'am. It wasn't when she was with me.
You signed your daughter, then you have to be declined.
I don't know where them pictures come from. No, ma'am.
Daughter also provided pictures of Nicholson office, sitting in the laundry room where y'all recycle.
Yes, ma'am.
Right. And the day we took it, my contest about today, there's twisted tea sitting in the cup holder of your girlfriend's TV. To make sure you come that out.
No, ma'am.
You understood that you cannot have alcohol in your house.
Well,
And that's because you made what could have been a fatal, irreversible mistake of driving drunk with your child.
yes, ma'am.
You understand our children do as we do, not as we say a lot of times?
Yes, ma'am.
So, if your children go up and see daddy drinking all the time and doing that, what do you think they're going to do?
When they get older.
Same thing. But you have learned your lesson, but you're still going to drink, even though the effect it has on your children, seeing their father punished. You drink when they're not there.
My kids, no, ma'am. When I have them, no, ma'am.
But you understand, your daughter testified that these were in your house when she was there during your residential time.
Okay.
That she took them and immediately and texted them to her mother. And her mother testified as to the date and when that was done. It was residential time. Can you refute what your daughter said and what your ex-wife said?
No, ma'am. I know there is none in our house.
Right now,
Right now, I've got the kids this week. Right now, there is not.
there's nothing in your refrigerator.
No, ma'am.
Okay.
You heard this statement, there's a twisted tea picture, it's February 2nd, you have it, don't speak of it.
I'd have to look at at the calendar. But if it's say here, the kids, I had them.
January 11th, twisted tea in the back. January 1st, beer in the refrigerator. November 23rd, twisted tea in the cup holder where you drive the beer. And again. So back right there it is. 1, 2. 3 occasions that your daughter has found alcoholic beverage. You subjected them to alcoholic beverage. But
I have not had no alcohol since the last time since the last time we were in here in November. I have not had none at the house.
Okay, well, and I want you to qualify, because your statement was, I've had no alcohol since we were here November 5th, and then you,
I have on the weeks that I do not have the kids, I do.
and how often do you drink?
It ain't daily. Might have a couple beers. It ain't really kind of set amount. It ain't nothing like it used to. I've learned so much over the last year.
When your son testified, he testified about, your daughter being upset because she got whipped. And I asked your son about why would she got whipped. It says, back talking, I think is what she said, smart mouth or back talking. And you punish her when she doesn't obey your rules.
Yes, ma'am.
And you're perfectly capable of obeying the rules of this court,
Yes, ma'am.
including not driving, not drinking to excess with your children, and at the beginning, and now not drinking at all, but also not possessing it or subjecting them to it in any way. You understand that? And you're capable of doing it.
Yes, ma'am.
And if you take your daughter's testimony and your ex-wife's testimony that corroborated her testimony is true, you violated this court's order on 4 occasions, haven't you?
I don't see that being true.
Well, you agree that you violated the court order by getting drunk and drive with your kid.
Yes, ma'am.
And then the 3 photographs that we have submitted are, if the judge finds those to be credible, that would be 3 other violations, correct?
Yes, ma'am.
So that's where I got my 4. And you're capable of understanding. You knew you weren't supposed to do it. And your testimony here is that, well, I just can't, I don't know. I don't know where the pictures were taken. Right?
I don't know where the pictures were taken.
Why do you think your daughter's out to get you?
I don't know if she is out to get me. I know she,
And again, I don't, attorneys say things in representation, and I just want to make sure and clarify that when this comes out, the questioning that he did with my client, you understood it was that Shaylin is out to get you.
Shaylin loves her mom. I know she loves me, without a doubt. I love my son. My son loves me. My son loves his mama. Yes, ma'am.
That's all.
Or you have redirect. Thank you, sir. You may stand down. You have any other witnesses? Mr. Robert, you have a rebuttal proof?
No, Your Honor.
I'll hear you in argument.
Your Honor, I'd like to say that, again, just as it pertains to due process, specificity, and perfected pleading, and understanding of exactly what it was that we were here today having alleged against us, it appears that the allegations are simply one allegation of alcohol in the home. Those are the only photographs. If these photographs existed prior, they could have simply been attached to the petition alleged as such. I have what appears to be a singular allegation against my client, stating that on January 31st, he was found to have an alcoholic beverage in the home. That, Your Honor, I have nothing further other than the understanding of effective pleading my client's due process.
Well, reading the petition for criminal contempt, seems to me it makes very clear that it sets forth the fact that there was an order that was entered by this court on November the 5th. And that it set forth certain restrictions, but even before that, the valid parenting plan that was entered in this court clearly indicated that there was to be no consumption of alcohol specifically by Mr. Phelps. That there was an agreement he agreed to, and the language of that parenting plan said that he should not consume alcohol to excess. In the petition for criminal contempt, it goes forth to say that he had violated that order, as he's admitted, by getting arrested for driving under the influence after having consumed 8 to 9 beers and driving the vehicle at 0.19, and that he had to their minor son with him when he was doing that. And that, he knew he had violated the restrictions on the parenting plan when he did that. Then I put an order down that was pretty specific. You know why? Because Mr. Phelps, I thought you were a good father, and I felt like it was a good, I think it's important for these children to have both parents in their lives. I think your children love you, whether or not they approve of what you do or not. I think your children both love you. There are certain kinds of cases that I absolutely hate to hear. This is one of them. I hate to hear cases where I have to have children. You have two good-looking children, two fine children. But we've just put those children through a ringer. Emotionally, I had to, I mean, you know, it is unfair to your children. But why is that? Why are we here today? Why are your children having to go back there and testify and cry in front of strangers like me about the situation? Why is that necessary? Only one reason it's necessary, and that is you're choosing alcohol over your children if you continue to do this. I understand you're a grown man. I understand you can drink anything you want to. You can drink yourself into an early grave as far as this court is concerned, and there's not much I can do about it. But I can control what you do around your children. And so when we were here in March, I tried to ensure that you would continue to have this equal division of time with your children, that you would continue to have an environment where you and your children could be together and they would feel safe, and that she would be satisfied that there wouldn't be any problems. So I put that order down. That order is not hard to understand. The order says the following. It is ordered, adjudged, and decreed that the respondent, Brian Keith Phelps, shall remain, and I think that's a topographical that said his schedule shall remain as set forth in a permanent parenting plan, but he is specifically restrained, enjoined, and prohibited from consuming, possessing in any way, or subjecting the party's minor children to any type of alcohol during his residential time, including but not limited to his own personal use, or allowing any other individual, including his current paramour, from consuming, possessing, or in any other way, subjecting the minor children to any type of alcohol. Now, you could make the argument, well, that doesn't keep me from having alcohol in the house. I just don't need to open it in front of them. Except for the next paragraph. It is ordered, adjudged, and decreed that there will be no alcoholic beverages at the home where the respondent is exercising his residential time. Now, why is that? Why did I do that? Because when you think about it, your son's already been through a traumatic experience. He watched his father get arrested. That's just something that doesn't sit well with this court, that would have to be the case. And I would have thought that out of consideration for your children, you might have thought more about the fact that knowing that your son was with you and your daughter, I think, came back to the scene and picked him up. And so they got to see their father being arrested because he was drunk on his butt. That is not one of your finest moments. And I would have thought maybe that would imprint itself enough upon you that you would not want to have alcohol in your house under any circumstances when they're there. Why? Because they see the alcohol, it reminds them of what had happened. It also puts them in a position where they wonder, is Dad drinking again? When they see it in there. Now, your daughter has taken pictures. I don't believe she broke into your house and took those pictures and surreptitiously did that. I think she took them when she was there because there was a box of beer in your refrigerator on the date that those photographs reflect. There was also alcohol cans there. And I don't know whether they were full or cold or hot or empty or what, but they're there. And that reflects the fact that you have little regard for this court's order. Why did I allow Ms. Roberts to go on a tangent about whether or not you drove this car with an interlock device or not? I'm sure you wondered why that happened. Because it reflects whether or not you are, number one, credible. And I don't find it to be credible that you thought you could get behind the wheel of any other car as long as it wasn't that interlock device car, and that you could drive any other car you wanted to. And that you just found out a few days after that. I think you thought you could get away with driving without having to do the interlock, and that was the reason you were doing it. So that's one reason, your credibility. The other reason is because it reflects whether or not you obey rules, whether or not you're willing to obey rules. And as a result of this situation, I'm now forced to have to make a decision. This is not your children's fault. This is only one person's fault, and that is yours. No one forced you to get behind the wheel of the car when you got arrested for DUI in violation of that court order. No one forced you to have these beer cans and alcohol present in your house. I find by the credible proof in this court that you have violated this court's orders on 3 different occasions, because the photograph of the can of beer in the vehicle was taken, according to my understanding, on a date that was before the last order went down, which was entered in December of 2025, that order, that photograph of the beer can was November the 23rd, so therefore it predated the entry of the order. So I found that instead of 4 allegations, I found that the plaintiff's proof has sustained and proven beyond a reasonable doubt that the defendant willfully violated the orders of the court on 3 different occasions. And each of those occasions, I ordered that he be sentenced to 10 days in the county jail. Under the law, I can sentence those consecutively, and I'm going to do that. So you're going to have a 30-day sentence hanging over your head. Now, I'm not going to require you to serve any part of that right now. You know why? Turn around and look over your right shoulder. See those 2 people sitting back there, and those 2 children? They had to come to court today and testify about things that were very unpleasant about their father. They love you. They cried too. So you go ahead and cry all you want to. But the fact of the matter is that they're not the blame. They're not the fault in this situation. So you've got a choice to make from this point on. You can have alcohol anytime you want to, as long as it's not in violation of your probation. Frankly, you violated your probation by driving that vehicle without an interlock. And if your wife really wanted to hammer you, she could report that your ex-wife, she could report that to the authorities in Montgomery County or Robertson County, wherever you're on probation, and you could very easily be charged with that. I hope that doesn't happen because it serves no purpose at this point. I think hopefully you've learned a lesson. So what I want you to understand is I'm sentencing you to 30 days, and I'm going to suspend that 30 days. But that's going to be hanging over your head to see whether or not you comply with this court's order. Because of something, and I don't expect that you're going to have another problem. But the other thing I want to tell you is that the 2 of you have these children, and you agreed to co-parent them. So right now you are still under that order. And you need to find a way to co-parent each other. You need to find a way to communicate and allow the two of you to be involved in your children's lives. Both of you may have moved on with other people, I don't know, but obviously Mr. Phelps has. But it is a situation where you need to think in every situation about what's best for your children. Your children love you. They want you to be happy. They want to be with you, but they want to be safe and not have to worry about whether or not you're violating a court order. So it is this court's order that the 30 days will be suspended, and that will conclude this hearing. So, anything else?
Not delay, it's suspended, it is suspended.
I'm sorry.
Again, his 30 days is suspended.
It is.
So future infractions, you're not reserving, I just want to make sure you're not reserving him spending additional 30 days of violence again.
If he violates the court's orders, he will serve this 30 days and any additional time that the court finds he's violating the court order. So this 30 days is suspended, and I'm suspending it and placing you on probation, so to speak, with this court, at least for the next year, for 11 months and 29 days, because it's going to misdemeanor.
So it's appropriate when I put suspended pending his future.
That would be appropriate.
Okay, thank you.
So you've got a decision to make on whether or not you want to have alcohol in your home when your children are there or whatever. You can do whatever you want to do, but the main thing I also want is to make sure that these children are not punished because they came to court. So love your children. Don't punish them for this. They've been through enough as it is. So, all right. That will conclude this hearing. Ms. Roberts will draw the order.
Your Honor, may I request also a strict prohibition from discussing the children's testimony or punishing them in any way?
Well, it says that, but I will say that.
I mean,
If I find that anyone has punished either one of these children for the testimony that they have offered, or even talked harshly to them, and it comes to my attention, I'm going to put that person in jail for 10 days immediately.
so I can put that language.
You can put that in the court order.
Thank God.
All right.
Mr. Paulson. Your Honor, if I could have a minute, we'll start next year.
Yeah, we'll take our afternoon recess.
Thank you, Your
We'll
Honor.
be in recess for 15 minutes.
Thank you, Your Honor.
The judge made it clear that the children were not responsible for what happened. The responsibility belonged entirely to the father. He chose to drive after drinking, resulting in a DUI while violating a court order. The judge also criticized him for having alcohol in his home despite clear restrictions.